You're live, sir. You're live, sir.
So, Amit, can you hear me? Dr. Amit George? Angel, see, Amit is here.
Just a sec. I'll just give him a call.
See, this is one topic which will require some time.
Yes, sir.
So, if we actually start in time, then only perhaps.
Yeah.
Right.
Definitely. Yeah. Good evening, sir. So Nitesh had officially muted me, so it is not my fault. He's now only.
You've done it with everyone, I guess.
You know, this seems to be a conspiracy with those who understand technology.
Right, sir.
We have already been dumped into this techno mess by both the courts as well as young Turks like you people.
So I request Amit, Dr. Amit George to take over from here.
Right. So good evening, everyone. At the very outset, our sincere thanks to Mr. Mohit Mathur for having spared the time to address us today. Mr. Mathur is not only one of the leading senior advocates at the High Court of Delhi, but is also the very popular president of the Delhi High Court Bar Association. Now, there is a lot to be said about Mr. Mathur, but one interesting fact which comes to mind is that he has a large number of interns at any point of time. And legend has it that to each of these interns, the introductory pep talk to the chamber consists of advice to completely forget what has been learned in law school thus far and to learn afresh during the course of the internship in light of how radically different things are in the real world of the courtroom. Now, such a scenario is also perhaps applicable to the topic of the present talk, which is appeals and revisions in criminal law. Whenever we discuss or debate the criminal law in a theoretical sense, whether in a classroom environment or otherwise, inevitably the topic of discussion veers towards the substantive aspect of the criminal law rather than the procedural. The reasons for this are not too far to seek. For one, it is a substantive part of the law that is more amenable to normative academic analysis as compared to the procedural part. Further, the circumstances and developments surrounding the substantive part of the law better endear it to posterity as compared to the procedural law. Now, famous tales of acquittals or convictions usually relate to an act of legal brilliance which revolves around a peculiar or unprecedented interpretation and construal of the law or the facts. In comparison, victories won on purely procedural grounds rarely, if ever, become a part of popular folklore. However, as any regular criminal practitioner would tell you, criminal procedure is really the beating heart of the criminal justice system. From the perspective of an accused person, criminal procedure imbibes and operationalizes the fundamental constitutional guarantee of a free and fair trial and sets out in stone the varied protections offered to an accused person. This is also clearly visible in the specific context of appeals and revisions, which represent a crucial march up the pyramid of justice, if one may use the allegory. Appeals and revisions are a fundamental concomitant of the right to be heard, of human fallibility in the process of adjudication, as also an assurance that an individual's freedom and liberty cannot be allowed to depend solely on a single untested decision. From a lawyer's perspective, criminal procedure can represent a gold mine of opportunities to bolster up a weak defense or inflict a telling blow upon the other side. However, if not properly engaged with or understood, criminal proceedings can very well end up as a chakravyuh in the procedural sense, where an otherwise good case may meet an unceremonious end. As an example, in the case of Hari Shankar versus Rao Chaudhary, back in the year 1963, the Supreme Court held that the distinction between an appeal and a revision is a real one. What exactly does this distinction represent, however, is still a matter of significant controversy many decades later. Simple enough in theory, but significantly more complex in practice, criminal procedure remains an area of the law that has witnessed relatively little discourse by regular practitioners outside of judicial pronouncements. We hope that today's talk by Mr. Mohit Mathur represents a small but important step in remedying this shortfall. Now, I would like to thank Mr. Nitesh Mehra, Mr. Angel Bharadwaj, and Mr. Anant Garg for having put this present session together and for having me over. Now, without further ado, I would now request Mr. Mathur to address us on the chosen topic for the day. Over to you, sir.
Thank you, Dr. George.
Thank you, Amit. Thanks, Angel, Nitesh, Anant, for basically baptizing me into this technology. And some of the young Turks of my executive and some of the you people who have been close to me have ultimately pushed me also into this technological jargons of webinars and virtual courts, virtual conference systems. Amit was right in saying that procedure is somehow always forgotten in the highlighted part of the substantive law, which actually also is more marketed, I would say. But the real substance does not lie so much in the substantive law than what actually goes into that process, and that's the procedural law. One needs to really master the procedural law, and that's one of the fundamental basis on which the legal luminaries in criminal law have always been pressing upon this point, that one needs to understand the CRPC more importantly than reading what the penal provisions of different statutes, whether it be IPC or the special statutes. Now, one thing is very clear. The appeals and revision, which is the topic of today, are vested with the courts which have supervisory jurisdiction. And there is a reason behind it. It basically lies in the concept of the common law, that it's a principle of natural justice that you get a second round of hearing. And therefore, in all judicial and quasi-judicial processes, I would say, appeals are incorporated. The provision of appeal only gives the person an opportunity of fairness in the procedure. Appeal, therefore, is statutory right, whereas revision is not a statutory right. It's a remedy, yes, but it has its limited aperture. And therefore, one needs to understand what actually in criminal law entails for you when you are actually looking at either an appeal or for a revision. See, the underlying principle in both is to place before the superior court the miscarriage of justice which you perceive has happened. And it is that perception which the appellate court or a revisional court looks into and then examines the material on record. And on that basis, it proceeds further. So one thing is very clear. You have to understand that appeal is basically like a fundamental right, or perhaps even in some of the judgments, it has been taken to be equivalent to a right under Article 21 of the Constitution, as a right to your life. and your right to fairness of procedure. So we need to understand what appeal in criminal law means in the criminal justice delivery system, and what revisions in a criminal justice delivery system under the CRPC actually give us. Now, one needs to also understand the criminal justice delivery system has undergone a change as far as India is concerned, because the procedure, the criminal procedure code, which the pre-partition, the pre-independence time we had of 1898, stood amended in 1973 and brought into force on 1st of April 1974. On the appellate forums, there is not much change, but on the revisional side, there has been a lot of change in the procedure. So I would caution everyone that in case you are looking at the judgments on revisional powers of the courts, then please be careful, because there are judgments in the past which you would find are not supported by the current CRPC. And the reason behind it is the old code, sections 437 onwards, which used to be parameterial, not exactly parameterial, but they correspond with sections 397 onwards as far as the revision is concerned, are much at variance. So I caution you from the starting itself that please don't compare judgments of pre-73 with today's procedure. So having said that, if one sees appeals are, the provisions of appeals are incorporated in the chapter 29, which starts from section 372 and ends at section 394. Now, appeals can be filed under the CRPC and for the general law after the conclusion of the trials, except that there is a separate appeal which is for section 340 of CRPC, where 341, the appeal against the order under 340 is passed. I am not dwelling on it further, because that's a very, very narrow compass and not worthy of a discussion here before all of you, because perhaps the occasion comes once in a lakh of cases of a 341 appeal. And perhaps it's only an ingenuity of lawyers like us who keep pushing 340 and 341 for the satisfaction of the egos of the clients, and sometimes also for our material benefits. But let's understand, appeals can be broken into three basic parts. One, appeal could be against a conviction. Second, appeal could be against an acquittal. And thirdly, appeals could be against inadequacy of sentence. Now, since the procedure code itself takes into account two methods of procedures, one initiated on a police report and the other initiated otherwise than on a police report. So we'll take it as a, for common usage of language, we'll say take it as a complaint case or as a state case prosecution. The appeal against conviction, which is a very common thing which most of the convicts always apply for, is prescribed under section 374. But there are certain exceptions which have been provided in the provisions of appeal. One, what's the scope if in case you have pleaded guilty and then you have been convicted? Which is a very small area which is permitted for you to challenge your the sentence. You can only challenge your legality or the extent of the sentence in case you have pleaded guilty and you have been convicted. But the normal appeals which are generally filed against convictions are after a prolonged trial and your full-blown examination of the evidence and thereafter. So in those scenarios, the appeal provisions permit the superior court to reverse the findings of the court below. It could even order retrial, set aside the judgment and order retrial in case it finds that substantive part has not been done. It could enhance the sentence after giving an opportunity to the person concerned that we are satisfied you have to be convicted, but your sentence is too meager. We need to enhance it. So you have to give a notice to the person. It can amend the order and modify the sentence, the conviction also, which we generally see in cases where the trial was under 302, but the conviction is under 302, but the superior court in appeal finds that no, 302 is not made out. It could be a case maximum of say 304, which is culpable homicide not amounting to murder. So it can modify the findings that it's not murder, it's not intention, it may be knowledge only. It could also take further evidence in the appellate court. Now, this is a very interesting part. Section 391 permits the appellate court to take onto itself this part of the trial, that if it feels that there is something very serious which has happened and something serious is amiss, and this evidence is crucial for the just decision of the case, it can under 391 even direct the evidence to be recorded before itself, where the counsels for the accused may be permitted to cross-examine the witness. Now, in the recent past, the High Court, as well, our own Delhi High Court, as well as some other high courts, have even carried out a re-examination of an accused under 313. Now, this is very interesting because what happens in appellate court, when you are in your appeal, you are trying to lay the blame on the prosecution of not having put certain evidence to the accused for him to be able to discharge the burden at the stage of 313. At that stage, sometimes the courts feel that perhaps acquitting the accused at that point merely on this technicality. Now, this word merely I'm using borrowing from the judgments, that they feel that it is merely on this technicality of not having confronted the accused with the evidence which is already against him on record, which according to the courts was there, but for some laxity was not put. So they re-examine the accused in 313. Now, one thing one needs to be cautioned, and by my little experience that I've had at the bar, we sometimes get flustered on this. There is no need to get flustered. Courts, for procedural sake and to do complete justice, may be adopting it. It does not mean that it is going against you. Somehow, an impression is gathered. The minute court wants to do something out of the ordinary, you take guard and you suddenly start feeling that there is something antagonistic which is happening. It is not necessary. Therefore, primarily, you must master your facts. You must ensure that you have marshaled both the law and the material on record. So in case, even if the court wants to add on evidence or re-examine you under 313, it would not make much of a difference as far as you are concerned. So that is one part of it. Second, please bear in mind, appeal being a statutory remedy cannot be dismissed in default. Records have to be called. The provision of law does say an appeal can be summarily dismissed. But Supreme Court has time and again deprecated such a practice. Supreme Court, right from I think 70, there is a judgment, landmark judgment of 1976, and then thereafter in 1983, Justice Chinnappa Reddy's judgment, which we have been using more often, is that it disapproves any summary dismissal of an appeal if there is a sentence of imprisonment involved with it. The Supreme Court has said time and again that the court must do complete justice, and therefore they must dwell on the facts, dwell on the law, see whether there is proper punishment which has been prescribed, it is appropriate, and therefore give a full hearing to an accused. Even for a summary dismissal, and this is very common practice in some courts, in the appellate courts, I have myself experienced, and in fact, through my growing years, we used to be intimidated, I would go to the extent of saying, where the court would say, "Hai kya is appeal mein? There is nothing in the appeal. Everything has been taken care. So why should we entertain? What is there?" Now, at that point of time, don't unnecessarily go on the back foot. You have provisions of law which support you. Even if the judge wants to dismiss it summarily, he needs to call the record and hear you out. So keep pushing. You have the law by your side. Second, most of us on criminal side are really more interested in the suspension of sentence so that my client should come out, and therefore we try to somehow weave around it. Now, in this weaving around, you don't need to actually completely go on the back foot or completely go on defensive. If your facts are good, if your case is good, material is available, go ahead. 389 suspension of sentence may not take place in the first instance, but you can always convince the courts again and again. You can come back, or you can go to, from the sessions, you can come to the High Court, or from the High Court, you can go to the Supreme Court. So, but procedure, you must understand, suspension of sentence is available to you, but merely for that, do not discard your remedy, that is the substantive appeal. Your appeal is your main primary relief. And in appeal, you have a lot of leeway because you can reappraise evidence. You can re-agitate evidence, reinterpret it. And if in case you feel yourself that additional evidence be brought, you can, as an accused, also as a defense counsel, also move an application under 391. It is not only the prerogative of the court to seek additional evidence. So additional evidence is available to both the accused as well as to the prosecution. Now, there is the substantive change which has come in the procedural law, and that is an appeal now can be maintained even by a victim or the complainant, as one could call. This was not available till 2009 December. In December 2009, the Criminal Law Amendment Act was brought in, and the provision of appeal being made available to a victim was also provided for. In that, for that purpose, Section 372, which is the opening section for an appeal, a proviso was added that the provisions for appeal would be the same for a victim as well. He can also maintain an appeal in the same fashion as as any appeal would lie. So in that very fashion, there has been some debate because in complainant's appeal under the complainant's for complainant's cases instituted on complaints, there used to be a provision under Section 378, appeals against acquittal, where you had to seek a leave to appeal. Now, that provision is generally for cases instituted on the complaints, or which are called otherwise than on a police report. There had been a debate between different high courts holding in a different view that whether in a state case also, if a victim is maintaining an appeal, it becomes maintainable, yes, but the whether he needs to file a leave to appeal or not. That has been put to rest in 2018-19 by a judgment of 3 judges of Supreme Court, which reversed the Satyapal's judgment of 2015 of Supreme Court of 2 judges, that now the law is that a victim does not need to file a leave to appeal. And his appeal is maintainable even without an application for leave to appeal. Now, please bear in mind why this provision of 372 proviso was brought in was because earlier the complainant had no right to institute an appeal if the state was not preferring an appeal. But in that scenario, he would file a revision. Now, revision, there was a bar under section 401 clause 3 that in a revision, no court would reverse a finding of acquittal into a conviction. So the satisfaction of a victim to challenge the order of an acquittal and seek a conviction for the accused of his case was basically being denied to him in view of this bar. And all that he could seek was basically a remanding of the matter to the trial court again for retrial, which in Supreme Court's language was loading the dice very heavily against the accused. Now, this phrase of loading the dice very heavily against the accused was basically being used to signify that once you are sending the matter back for, remanding it back for retrial, you are basically telling the judge to convict the accused. Now, keeping all that in the backdrop, the legislature amended. So now the question came for the appeal to be preferred by a victim as well. Now, something which I need to advise you as youngsters, if the youngsters are the audience, since I cannot see the faces, but those who are in any case starting on the filing an appeal and all, please bear in mind that the time which it takes generally from the filing of the appeal to actually its hearing, the person who has filed may not be the person who ultimately argues the appeal. In that scenario, the accused would suffer. And why he would suffer is the High Court rules and orders only require a challenge to the order of the trial court, the judgment in question, where you can simply say that the judgment of the trial court is bad on facts and law. Some simple grounds are sufficient to maintain an appeal. But ultimately, when you come to argue the matter, you have made certain notes in the past while preparing an appeal, but those are not available to you. So in such a scenario, it is always better to at least put your appeal grounds of appeal in some manner where you can have they have a recall value and you can recall those things. So drafting of an appeal, though on the criminal side, we generally have this tendency, okay, 2 pages you file an appeal, 3 pages you file an appeal, that's good enough. It may be good enough, yes, as far as the technical part of it is concerned, to sustain and maintain an appeal, but to actually argue it out, you'll need to then refresh your memory, go through all the facts, all the entire judgment, all the material. You might as well just to recapitulate your points, you can have most of them in your appeal. So when you draft an appeal, please don't go by the general advice of keeping minimal in your appeal. Now the facts are already there, so better give your grounds properly. So you also, or anyone whom you are asking to represent you at the time of hearing of the appeal, knows what are the important points in an appeal. Now, when we come to revision, please, everyone must realize, revision is not your right. It's a discretionary release which has been given. Now, the provision of section 397 of the code categorically gives you a narrow aperture as far as the revision is concerned. For maintaining a revision, the supervisory court has to call for the records. Now to do what? They can look into the correctness of any finding, the legality, the propriety, or the irregularity of the proceedings before a trial, the subordinate court. Now, somewhere down the line, we miss out. Revisional powers are also powers of supervisory jurisdiction of the subordinate court, which in the High Court are otherwise vested under 483 as well for magistrates. But the scope of a revision is being provided concurrent both for the High Court as well as for sessions under 397. The powers which the revisional court can apply under 401 categorically includes all powers of an appellate court. There is a bar for converting any conviction into an acquittal into a conviction, but at the same time, revisional courts have a power to convert a revision into an appeal if in case they find that actually an appeal lies and the revision has been filed by mistake or unwittingly or wrongly in terms of section 401 clause 5. In the last about 10 years or so, there have been a lot of debates on clause 2 of the revisional powers, that's 401 clause 2, where the court said, the court says no person to whose prejudice an order is being passed, an order should be passed to the prejudice of anyone unless and until that person has been given an opportunity of being heard. Now, this is very interesting. This is basically akin to principles of natural justice. But earlier, what used to be done was, in cases of a dismissal of a complaint, people would challenge it in a revisional court, get it set aside, get an order of further inquiry, or in a 156.3 case, they might be, the situation might be that in a 156.3 is rejected. Would you want to then go in and challenge it in a revisional court and seek an order of 156.3? This was put to rest by the Supreme Court in Raghunath Singh Rosha's case by saying that no, even in a case where 156.3 has been rejected, application for investigation, or even if a person has been discharged, the complaint has been dismissed, though it is prior to the summoning, yet in a revisional court, the proposed accused also have to be heard. So it widened the scope of 412 to include people who have not even joined or participated in the proceedings. Then even those people have to be called so that they can answer your proposed complaint. Although their answering also is very limited, the scope of their rebuttal is very, very narrow, but they have an opportunity and they are made aware of the situation. Revisional courts also face a very peculiar problem, and the lawyers who are seeking revision of the orders are generally also flummoxed on the point whether a revision is maintainable or not, because there happens to be a bar under section 397 clauses 2 and 3. Now, clause 2 of section 397 bars any revision to an interlocutory order. Now, interlocutory orders are a very vague term because they don't seem to be defined in the code. Courts have defined it. Now, even after the, what do you call, an interlocutory order is passed and a person feels that whether it is an interlocutory or not, one has to test, is it an order interlocutory to all, or is it a situation where the interlocutory order may be interlocutory for some, but it is also the, it's a final order for some. A third party may be affected by an order, interlocutory order passed by the court. For that third party who is not an accused or who is not before the court, then in that scenario, that order would be a final order. I am getting some questions. I would be requesting everyone, see, if too many questions keep on coming, then I'll not be able to complete the session. So please hold the questions for the end so that I'll answer it then. Sorry for the interruption. What I was saying was, in such cases, the courts have been saying that these orders are intermediate in nature. And intermediate orders can be revised because they are final for the moment. Now, please understand, in any criminal proceedings, any order may have their fallouts. So when you have to decide if it's revisable or not, you have to see whether the effect of that order is final qua the person who is challenging it or not. Therefore, 397(2) is not a complete bar as far as the order is concerned, but is a bar when you have to see it from the perspective of the person who is approaching it. I hope I have made my point clear. I'll repeat it. It is that bar operates on the person who approaches. Therefore, if that order is an interlocutory order for the person who approaches the court under revision, then it is a bar. But if it is not so and it is a final order for that person, then it is revisable. Such was a situation which arose way back in 1976 in a case where the matter was taken up by the Supreme Court when a lady was called to the court to produce some documents. Though she was neither an accused nor the complainant, nobody. Under section 94, she was directed to produce the material and appear in court and testify. The Sessions and the High Court did not agree with her. Supreme Court came down on and laid down the law that in cases where the person to whom the order is actually affecting, if that order is a final order for that person, then it is a final order and therefore revisable under law. As far as interlocutory orders are concerned, lawyers in the High Court generally have a tendency also to say that if nothing else, file a 482 because they stand covered under 482 in any case. The second bar is on what they say a second revision is not maintainable, because from a magistrate, if you've gone to the sessions in a revision petition, then that order is not revisable in the High Court under 397 because of the bar under subclause 3. Now, there has been a debate in the past whether, as laid down in Amarnath's case, would the revision be maintainable under 482 or the 397-401 or not, and would a 482 lie in such a circumstance? Amarnath was a 2-judge decision, and the judgment of Supreme Court in Krishnan versus Krishnaveni in 96 or 97, if I mistake not, it categorically said that no, 482 is available because 482 says nothing in this code shall be deemed to limit. And that includes even a bar under 397(3). So in case you have an order which you need to challenge and you feel that the sessions, I have exhausted my remedy under sessions, how do I go? You go under 482. Though at that point of time, my recommendation to all those who come to me is always If it's an order of a magistrate, please include 483 also, because 483 includes the plenary powers of the High Court. So the plenary powers of the High Court to supervise under 483 is always available, irrespective of 397, the bar under 397. Now, revisions are also filed in cases of convictions and once the appeal has been rejected. A magistrate's order of conviction, appeal dismissed by the sessions, one tends to file a revision in the High Court. Now, when you file a revision in the High Court, the problem comes that there are two concurrent courts findings against you, and therefore the question which arises is whether such a thing would allow you to enlarge the scope or not. But as I said, 397 allows you to go into the correctness of the findings. Now you have to please enlarge the scope in your respective cases of these words. These are a very, very wide words which can encompass over a wider area. Correctness of findings, illegality of an order, propriety of an order could even go to the extent of the sentences, and otherwise regularity of proceedings. So the aperture may be narrow, but it is not closed. So revisions can be filed. And I believe if you believe on your case, you must file it, because that's the only way you can test and take your remedies right up to the maximum which is available to you. That's on the side of the revision. Now, revisions, there are generally people say, and the courts also say, that the revision is not your right. So therefore, we can't look into it in revisions, especially against charge. My advice to each one is that if you are in case you are coming to the High Court, add section 482 along with the revision, the powers of revision. The reason being that the scope of 482 allows you to raise better points. Now, these are practical aspects of the procedural law. Don't get bogged down by what is written in one section. The code is of 484 sections. There may be some other section which provision of law which helps you out. So please utilize and play with the procedure to the best of your ability and for the best of your client. So with this, the one thing one must understand, that appeals and revisions are where you are challenging the orders of the subordinate courts. To be able to raise these points in appeals and revisions, it is very necessary that you have raised these points in the trial court or in the subordinate court as well. One thing under the High Court rules, please bear in mind that if you want to challenge a conviction after dismissal of an appeal in revision, then you also need to file along with it the memorandum of appeal, which we sometimes miss out. For the reason, because very seldom do we come from the magistrate to the sessions and from sessions to the High Court. So just have the procedure on your tips so that helps you out. And there are certain things which you need to understand is that in an appeal, these are incidental things which happen in appeal, and that's why I'm going to just traverse them so that you get a hang of things and you're not taken by surprise. There is a provision of compensation along with the sentencing. Now, there is a specific victim compensation scheme which is drafted by each state in terms of section 357 capital A. And in cases, those dealing with 138, etc., may have to deal with the compensations which are being afforded. You'll need to go through the section 357 once, because that provides that if in cases compensation is provided, then that compensation is not payable till the appeal is disposed of. These few things which help you in ultimately your helping out your client. So please go through 357(2). There is a bar of the compensation being made to be made payable or not till the appeal is provided. And 357A may be handy for you in case you're dealing with a victim. So victim compensation schemes are there by each state. In Delhi also there is. And recently in a judgment by Justice Hema Kohli and Justice Manoj Ori, I'm forgetting the name of the case, in an appeal where 302 was provided for, the person was convicted in a 302, the court found that it did not actually happen in the way the prosecution was trying to portray, but still the man seemingly is guilty of the incident and therefore guilty under 304. The High Court awarded compensation to the victim's family and directed the state to find out where the victim's family was and to provide that compensation in terms of that scheme. So even in appellate stage, compensation can be provided. So as a counsel, it can sometimes even become your bargaining chip for getting your sentence reduced to a sentence which is, more like that you've already suffered, already undergone, and then at that point of time, after a gap of years, you really don't want to go back into the jail. So you would want that ultimately, if I can compensate the victim, probably I may be let go. So in those scenarios, you may ask for the compensations to be provided. Now, suspension of sentence, I think would be akin to your seeking bail. Only thing that will go against you perhaps is that there is a conviction and you are not an under trial. But if you are able to show to the court, and there are some number of judgments, Akhtari B and thereafter Sudhir Jain, etc., where the Supreme Court has said that if in case you're not hearing the appeals and not likely to hear the appeals in time, so might as well in the finite sentences, fixed term sentence, as we say, the suspension of sentence may be provided. So that is as far as those are concerned. I would only like to say that there are certain special statutes which you would as a criminal lawyer be dealing with. And in cases of those special statutes, you would also find, and new ones are coming with economic offenses and all, you have to keep in mind what does the special statute say as regards the applicability of the criminal procedure code where the appeals and revisions. Because in the past, the stricter laws like the TADA, etc., only provided for an appeal straight to the Supreme Court, which was upheld because the Supreme Court felt that in serious cases, we don't want to waste time, we don't want to waste energies, no appeal or revision lies except a challenge to this court, the Supreme Court. And in recently in the coal scam cases also, Supreme Court has in their own judgment, by their own judgment, and thereafter reaffirmed by another 3-judge decision, said that all orders are challengeable to the Supreme Court except those in the end of the trial. So even if you want to challenge the order on charge, you have to go to the Supreme Court because there's no revision which lies. But the trial, when it concludes, has to go by the appeal which comes to the Supreme Court, to the High Court. These are peculiar cases. They obviously don't end up making the law, but yes, they make the law a little trickier. So I would only request each one that whichever part or whichever concept you are dealing with or you are trying to understand, please see what the law, if there is a special law, what does it say? Does it bar? Does it enhance your scope? Does it help you out in any manner? Now, there are a couple of things which I always say you need to understand in appeals and revisional jurisdictions is that the order which is being challenged should also conform to the provisions of law under which that order is to be passed. And why I say so is, many a times, if you find that an order exceeds its jurisdiction, courts will come to your aid. Similarly, there have been where a judgment after trial does not conform to section 353, 354, the manner in which a judgment has to be laid and the manner in which it has to deal with the evidence. In such cases, Supreme Court as well as our own High Court have set aside such judgments and sent it back for further hearing, re-arguments, and then reappraisal of the evidence by the trial court. So if you know the procedure, if you understand the procedure, if you know that a particular order which is seemingly passed under a particular provision is actually not passed under that provision and does not conform to those the tests laid down in that, then also you get the benefits. So ultimately, all in all, you need to master your procedural code. And if you can master your procedural code, you will find ways out, you will find ways in, and you can then probably succeed much faster pace and much better and more efficient way. So thank you for your patience, and thanks so much for allowing me to speak all this nonsense. And just on the side, one instance I'm reminded when we talk about strange situations and strange things is in my personal experience, and at that point of time, Justice S.K. Agarwal, as he was the standing counsel, the division bench of our own High Court, while hearing the regular appeal, looked at the appeal, looked at the evidence, and started laughing. And obviously, we on this side did not understand why they were laughing. And it was Justice Devendra Gupta and Justice Nandi's bench. He said, please look into the evidence, Mr. Mathur. I was a junior counsel at that time. So I looked into it, went from top to bottom, couldn't understand even a iota of what they were trying to hint. He said, so this is the cross-examination. You have said nil cross-examination in your eyewitness cross-examination. Before I could say sorry, they started laughing again. So I thought I might as well go through the examination in chief. I went through the examination in chief, and interestingly, the eyewitness had not identified the accused in court. He had not said, so-and-so is the accused who did this act, and I identify him, he's in the court. Merely on this point, Justice Devendra Gupta and Nandi acquitted us. Two accused, both acquitted, thankfully, on this mere technicality. So please marshal your facts, marshal your points. You will know something will just come in handy for you in the appeal court or in the review. Thank you. Any questions, Anand, Nitesh, whatever?
Hi, sir.
Hi.
Sir, thank you for your time and valuable guidance. We have some queries from participants. Should I start?
Yeah, please.
One of the participants has asked that there are different considerations that weigh with judge while hearing an appeal against acquittal versus appeal against conviction. What could be the rationale behind this?
See, as the entire concept of appeal goes, that men are fallible and even judges are men. So that's why the appeal provisions are provided, that one man may have been fallible, give a chance to the other, a superior one. Similarly, see, appeal against conviction and appeal against acquittal, the parameters why is they are dealt with in this way is the yardsticks which are different for a same judge is also because there is a belief that a man has undergone trial. He has been able to establish before one court his plea that he is not guilty. So when it comes to his acquittal, one court has already held an acquittal in his favor. Now, we all know the concept. If there are two views possible, the one in the favor of the accused has to be given. So on that basis, an appeal against acquittal always starts, you start with 2 feet back. So you have to start with that you have to first come to a ground neutral, ground zero, and then start making something, make some headway. But when it comes to the conviction, he can only go forward. He's already has his back to the wall. He can only try to show to the court that there is an error in the findings, there is an error in the appreciation of evidence, and therefore a neutral judge, I would say, would generally be in favor of listening to an appeal against conviction with more care and caution, and give that benefit of doubt to the person, to the accused respondent in case of an appeal against acquittal. That's the only rationale which I can think of as a prudent person.
Thank you, sir. So then there is another query. Somebody has asked that is it possible for you to give some pointers which person has to keep in mind while drafting an appeal against acquitters? Although it is already covered in the first query, but if you can elaborate something on this.
See, 2-3 things I would say. Just as an advice, you can take it as an elder to a younger person. I'm giving as an advice. Pick out what's it that weighs in the mind of the judge. In a case of appeal against acquittal, he is looking for perversity. So you have to highlight perversity. You have to highlight that the finding is just not possible. And therefore, in your draft, you have to keep on emphasizing on this fact that, look, the trial judge has erred in finding, and his finding is perverse to such an extent. Now, this is where your emphasis and that's why I said your drafting has to be good, not cursory, whether it be appeal against conviction or against acquittal.
Thank you, sir. Sir, then somebody has asked whether it is possible for two persons to file a complaint for the same cause of action. Like,
see, I don't personally agree to a joint complaint because according to me, there is no concept of a joint complaint. But however, I have been held wrong by a couple of courts by saying that what's the point in two people filing same complaint and then reclubbing it? So technically, according to me, personally speaking, you should file two separate complaints and then have them clubbed because the trial can be joint. That's my take on things. But courts have, in one of my own cases, which I challenged, I was asked to withdraw it because the courts were feeling that no, what's the point in unnecessarily you want to increase paperwork?
litigation.
Two people are filing or 6 people are filing, how does it make any difference?
Angel, if you have some queries, you can take.
Yes, sir, I have 2-3 questions lined up. One is by Miss Isha Agarwal. She's asking whether an order of grant or refusal of remand is revisable.
See, grant of remand is otherwise challengeable by you, according to me, in a 482. Rejection of a remand, the prosecuting agencies can definitely challenge even in a revision because that has brought a finality to the remand. If you have rejected remand, and one such case is Narendra Maan versus State, in which we were counsels as complainants counsels. We had initiated a complaint which became an FIR. Man was arrested and he was released on the day 1. After arrest when he was produced for remand. The Delhi High Court set aside that order and put him back on the same spot of remand application to be reheard because the revisability was in view of the fact that once you have rejected the remand, you have basically set him free. So it's an order which has attained finality. That's why I said it's an interlocutory order, qua one person, it may be a final order, qua another. So you have to see the impact of that order on the person who's approaching.
So taking up one of the common questions which we see generally. So this is a question by Megha Anand. She asked whether an order of 156.3 is revisable against the registration of FIR. It's a very common question which comes up amongst the youngsters. So,
see, there is Father Augustine's judgment of Allahabad High Court which held that it is not revisable. It's an interlocutory order. But our own High Court, Justice Gaude's judgment, Sunil Manohar or something like that, categorically says it's a revisable order. See, again I say, it is a revisable order because once you have directed registration of an FIR, you have made it final qua the person against whom the FIR is registered. So the proposed accused, it has become final. So therefore it is revisable.
So thank you so much.
As a High Court lawyer, we always say bring it to the High Court under 482.
That's always there, sir. So nice of you. For the other questions that are popping up, we would definitely take a reply from the sir by sending it on his email or through the.
Yeah, that's what I was about to say, Nitesh, Anant, Angel, and Amit, that you can forward these questions to me on my mail. I'll answer it. I have no issues. Aajkal वैसे भी we are all free. We have ample of time and love to do some academic exercise rather than just sitting at home and reading novels that hardly serves, nor Netflix. And you have my number 98712 00021. Anyone can contact me on that. I have no issues. Thank you.
Everybody, sir, for a minute, we would like to conclude. Everybody who has not noted down, may kindly note it down, sir's number, and trouble him anytime when you want.
Yeah. No problem. Otherwise, also, आजकल तो सिर्फ एक ही call I get. When are the courts reopening?
For which I think answer is the most difficult one.
I can't say it on the public forum, but सही में मन करता है दिल की भड़ास निकालने का.
So, sir, I would be concluding today's webinar. Sir, I would like to thank Mr. Mathur from the bottom of my heart for having spoken to us on this very important topic. Sir, right from my initial days when I have seen Mr. Mathur arguing in the court, it has always brought us of a learning experience. Sir, today we are very lucky that you have spared a time from your precious time, sir, and having attention on such crucial topic, which otherwise we could not find in the books, sir. So much of practicality was involved in this. And sir, I also want to say that despite sir is busy in the administrative issues of Delhi High Court and taking all the measures, whatever to be required on the behalf of the bar, sir has very kindly accepted and consented for today's lecture.
Thank you so much. I was trying to shut down the Facebook page, and as my technical knowledge is so immense that I could not even search for where is that button where I have to switch it off. So,
sir, we hope that we will be hosting more of such webinars and informative sessions along with you in the future also. Thank you so much for this wonderful time, sir, and we are very much obliged for this kind lecture, sir. Thank you so much.
So much. Thank you.
And I'm also thankful to my associate friend Angel, Amit, and Anand Garg for sparing their time for organizing today's webinar, and to the live law also. Thank you so much, sir.
Everyone, and God bless you all.
Thank you so much, sir.
Bye.